Amid a drip, drip, drip of revelation after revelation after revelation that Justice Clarence Thomas repeatedly failed to disclose lavish financial gifts from billionaire and right-wing activist Harlan Crow, the Senate Judiciary Committee is pushing Crow for a full accounting of the extent of his financial relationship with Thomas. In a letter sent last night, and according to the Washington Post, the senators are, quote, asking Crow and 3 companies associated with him to provide an itemized list of gifts worth more than $415 that he has made to Justice Thomas, any other justice, or any justice's family member, as well as a full list of lodging, transportation, real estate transactions, and admission to any private clubs Crow may have provided. The letter emphasizes this information will help identify specific shortcomings in the Statement on Ethics, Principles, and Practices, as well as current law that legislation needs to address. Crow has given hints, however, that he may be as unwilling to disclose his financial particulars as Justice Thomas has been. NBC News is reporting this, quote, Senate Finance Committee Chairman Ron Wyden last month asked Crow to provide a full account of undisclosed trips, gifts, and payments he has made to Clarence Thomas over the years. An aide to Wyden saying the chairman, quote, received an obstructive letter from an attorney representing Crow late Monday night, which refused to provide answers to Wyden's request. And in more ominous news for Thomas, Bloomberg News is reporting that Senator Sheldon Whitehouse is pressing the U.S. court system for information about how its governance body responded to Clarence Thomas's failure to disclose his wife's income in 2011. A committee of judges concluded that Thomas's lapses in reporting Ginny Thomas's income was not willful misconduct, but details about that review and the panel's reasoning were not shared with the public. Joining us now, the aforementioned Senator Sheldon Whitehouse, Democrat of Rhode Island. He's a member of the Senate Judiciary Committee. Senator, thank you so much for being here.
My pleasure.
We've been covering your efforts to reform isn't a strong enough word, it doesn't seem anymore, but try to shine a bright light on the misdeeds and questions of real failures to disclose. But I wonder if you can first address whether Senator Feinstein's return to the committee allows you to start issuing subpoenas and taking a more forceful posture when it comes to attempts at oversight and investigation.
It restores our majority. Which means that if we can get unanimity among Democrats on the committee, we're able to move judges who the Republicans are not willing to support and also pursue investigative efforts.
When it comes to the court, is the priority investigating the conduct that's been now reported by multiple news organizations, or is the priority a new code of ethics to stop? I mean, just take me through what your priorities are for the court.
Sure. Well, first of all, it's to understand exactly what took place with respect to all of the donations that have been filtered through to the Thomas household, not just from Harlan Crow, but also from Leonard Leo, who is the sort of fixer in the billionaire effort to capture the Supreme Court. So that's a very significant issue. Then we need to understand the judicial process for considering these concerns. Because the last time this happened on very similar facts, Harlan Crow, yacht travel, jet travel for Thomas, it went down into the Financial Disclosure Committee of the Judicial Conference and no public report ever emerged and no referral to the Attorney General ever emerged. So because we're on that track again with these new revelations, we also need to look back and see what took place in the last set of revelations. And finally, this is not the Clarence Thomas ethics scandal. This is the Clarence Thomas ethics scandal appendage to a much larger inquiry that needs to be made into a very robust, billionaire-funded, very secretive effort to capture and control the Supreme Court. And so there's lots of investigative work that we need to pursue towards the goal, which your last segment expressed so wonderfully. Thank God for honest courtrooms, but we need honest courtrooms.
Well, and I know this is something you've been working toward and talking about for years. The country seems to have caught up with you. Confidence in this court has plunged farther and faster than any institution in public and civic life. Would you like to see John Roberts? I mean, I know the answer would be yes as a partner, but I guess a better way to ask the question is, can you do anything meaningful to change the lack of transparency, the lack of ethics, and the appearance of impropriety on the court without some buy-in from John Roberts?
I believe there are several pathways, but I believe one very credible pathway is the one that we deployed when we were persisting at investigating Justice Scalia's plan to receive free hospitality when it came via personal invitation, even if he had no personal relationship with the donor. And when we persisted in pressing that question to the Judicial Conference of other judges, the other judges slapped that behavior down very forcefully, clarifying that what had been done was actually not lawful and should not be done any further. And Clarence Thomas said, "Oh, okay, I'll adjust my conduct accordingly." So there's a track of the Judicial Conference applying itself to these ethics problems and sending signals to the Supreme Court that they need to clean up their act. So that would be very important. That's why I sent this recent updated letter to the Judicial Conference to focus them on those issues.
I want to ask if we understand this correctly. We've, in sort of understanding the revelations, and again, without your majority on the committee, we haven't seen, most of this is coming from journalists and journalism. But there's a fundamental lack of transparency in the dark money that you've been talking about for many, many years, which seems to flow back and forth between the special interests and the conservative justices. There's a lack of ethics for the Supreme Court and the Supreme Court only. They do not abide by the same ethics rules that govern federal judges. And then there seems to be this third bucket of a lack to abide by their own meager disclosure and ethics laws. Is it that third category where you have questions of potential illegality?
That third is probably the center of the concentric circles of investigation that are required, because that's very immediately in front of us. And I think that the measure that the court says it's following is the same code of ethics and the same disclosure statutes that all the judges have to follow. And when they don't, I think that puts the other judges very on edge. The fundamental problem here is that the Supreme Court gets to call its own fouls. And they've gotten very sloppy about never calling any foul on themselves or on each other. And they're now operating way out of bounds with where other federal judges know they have to behave.
As a distraught Warriors fan, I think that's a very apt way of describing it. Let me ask you this about this third category. Will the Judiciary Committee, with Senator Feinstein back, begin discussions about subpoenas for people like Mr. Crow or Justices Thomas or Roberts themselves immediately?
Well, we are going to continue the investigative work, both on the Judiciary Committee and in the Finance Committee, where Chairman Wyden has a very important role, even though he was rebuffed by Harlan Crow's lawyer. There is more to be done in both cases, and I think we as people concerned about this court need to do a very fair but also very thorough job of bringing the facts forward before the American people. And I think both committees are going to be working to get the information necessary for us to take the action and perform the oversight we need to do.
I feel like if the court were interested in understanding why the public's trust in it had plunged, as I said, so far and so fast, and they called you could tell them exactly when, why, and how. But if I asked you to sort of to pull back and give a wider picture, I mean, it seems that the court relishes issuing opinions that it loves to underscore, fly in the face of 85, 75, super majorities of the American people, as they did in the majority opinion and the concurring opinions of Dobbs. And they seem disdainful, scornful, and angry at any journalism that seems to point to their own lack of ethics and disdain for their own ethics code. Is there anything else that I'm missing? Is there any other part of that?
No, I think that's really the issue here. And if you want to put a very fine, clear example of this forward, it would be Justice Thomas ruling in the case regarding the January 6th Commission's investigative powers, which led to his own wife's emails. The question of whether that was lawful or not depends on a fact, a simple fact. What did he know about his wife's insurrection activities, and when did he know it? And if there's one thing that tells you how off kilter the Supreme Court has become, it is that he has never been officially asked that question.